Welcome back to the Making International Law in Korea video series. In this video, I'll be explaining on the armistice agreements in the international maritime law. To properly understand the waters of the five islands in the West Sea, one must recognize the Korean Armistice Agreement. The Armistice Agreement, which regulates war and peace on the Korean Peninsula, is a product of the Korean War. But it is the way to end the war and move for the peace. The basic purpose of the agreement is to prevent hostile acts and promote peace. It is stipulated in the agreement that the five islands in the West Sea and the Han River estuary, unlike the demilitarized zone on land, are open for public access. We tend to forget this point. The Armistice Agreement divides the border between two Korea into three zones: the DMZ, the Han River estuary, and the five islands in the West Sea. The DMZ, defined as a military buffer zone that restricts the control, the civilian access and traffic, is facing directly against the military demarcation line. On the other hand, the Han River estuary does not have a military demarcation line, but is open to navigation by private vessels from both South and North Korea. However, the Military Armistice Commission and the UN Command have jurisdiction over ship registration and civil administration. Moreover, the five islands in the West Sea have no military demarcation line or designated waters under jurisdiction of the UN Command. South and North Korea have only declared the principle of respect for territorial waters. Therefore, in principle, vessels from third countries are allowed to use the waters in accordance with the international maritime law unless they intrude upon territorial waters. In principle, then, just as South Korea fishing vessels can sail through the Yangtze River basin in China, it is also possible to enter the offshore area of the Nampo Sea of North Korea. Likewise, North Korean fishing vessels can also carry out fishing activities in Gyeonggi Bay of South Korea. According to the Armistice Agreement, the South and North Korea fishing vessels can freely sail up and down and operate as long as they do not intrude the adjacent coast. No one, including the UN Command, can interfere with such practice. The idea that a military demarcation line should be drawn in waters as it does on land merely reflects the unconsciousness of the national division. At the time the Armistice Agreement was concluded, the principle of freedom of the high seas was established under international law. Also, the UN Convention on the Law of the Sea, which stipulates 12 nautical miles of territorial waters and 200 nautical miles of the exclusive economic zone, was not in existence then. Therefore, it was impossible to even think of drawing a ceasefire line separating sea from the north and south. However, North Korea, with its weak naval power, was not satisfied with the set principle of freedom of high seas and 3 nautical mile territorial waters. North Korea referred to military demarcation line from the beginning of the armistice talk. After the Armistice Agreement was signed, the Military Armistice Commission also claimed the extension of land military demarcation line or an extension of Yellow Sea and Gyeonggi Island as the maritime military demarcation line. Since then, as the development of the international maritime law has led to the claim of 12 nautical miles of territorial sea, as well as the 200 nautical mile EEZ, North Korea has declared its military sea boundary as well as maritime border in the waters of Fire Island in the West Sea. In response, South Korea also declared a 12 nautical mile territorial sea and a 200 nautical mile EEZ. South Korea has secured the northern limit line as a maritime military demarcation line. Thus, the waters of 5 islands in the West Sea that overlap the EEZ of the 2 islands have become an area of conflict and hostility. The original spirit of the Armistice Agreement, which incorporates the principle of freedom of high seas to be applicable for both South and North Korea to share its waters except for 3 nautical mile territorial waters, has now disappeared. Tensions in the West Sea eventually led to a series of military clashes between 2 Koreas, starting with the Battle of Yeongpyeong in 1999. We hope that South and North Korea will find a peaceful solution by upholding the spirit of the Armistice Agreement. The solution is to identify a 3 nautical mile EEZ in a continuous zone of the West Sea, and the seas beyond those areas should be used as shared waters for peace and consideration by the 2 Koreas. It will be the first step toward the peace agreements on the Korean Peninsula. Let me touch upon the flexible approach needed for maritime delimitation of the 5 islands in the West Sea. The UN Convention on the Law of the Sea, signed in 1982, established a legal framework for all activities in the ocean, established a maritime zone that can be claimed as territorial. The general rules for determining territorial waters are set out in Article 15, which state that boundary between 2 countries is set as the median line. However, the Convention does not specify how the EEZ should be delimited. The delimitation of EEZ between states with opposite or adjacent coasts is stipulated in Article 74, which states that the delimitation shall be effected by agreements on the basis of the international law in order to achieve an equitable solution. Accordingly, the laws and regulations related to the delimitation of maritime boundary are generally developed and crystallized by the cases decided by the international courts. In the case of maritime delimitation of the Black Sea between Romania and Ukraine in year 2009, the International Court of Justice applied the so-called 3-step approach to decide the maritime boundary. This approach is recognized as a common practice in delimitation of maritime boundary through the subsequent rulings. The 3-step approach or 3-stage approach consists of the following. The first, setting the provisional equidistance and median line, and second, considering whether there are factors that require adjustment of equidistance line or median line to achieve equitable results, and third, checking to make sure that the adjusted boundary does not produce the unequal result due to the serious imbalance between the ratio of the length of each country's coastline and the ratio of the relevant sea area that will belong to each country. What then would happen to the final delimitation of the maritime boundary of the 5 islands in the West Sea when applying this 3-step approach? Well, it is not certain as to how the hypothetical median line in the first step will be changed through the second and third stages and finalized at the end. This issue will be clarified if South and North Korea take the case to the international court. If 2 Koreas try to resolve the dispute through bilateral negotiations, the 3-stage approach or 3-step approach is likely invoked due to the predictability of the outcome. However, the problem is that the waters of 5 islands in the West Sea are not just a matter for South and North Korea only, but it is an area where the jurisdiction of 3 countries, Korea, China, and Japan, overlap to some extent. Any change in the legal status of maritime order between South and North Korea could affect the establishment of the maritime order between South Korea and China and North Korea and China, as no agreement on a maritime boundary has been made between these countries. Consequently, it is necessary to take a flexible approach to the traditional approach, which is centered on securing jurisdiction and establishing maritime boundaries, and simultaneously seek ways to manage and find a proper means of dispute settlement in the waters concerned. The UN Convention on the Law of the Sea divides the sea into territorial waters, continuous zone, EEZs, and international waters, and functionally confers right to coastal and non-coastal countries. The waters of the 5 islands in the West Sea and the national jurisdiction should be minimized. It is also important to seek ways to manage the water in an integrated manner while coordinating the interests of both South and North Korea. Furthermore, except the continental boundary agreement between Korea and Japan in 1974, the current maritime order, which has no maritime boundary with neighboring countries, should be considered as a product of the dynamic relations between these neighboring maritime powers. In addition, if South Korea is to secure at least some leading position in the Korean Peninsula, it is critical that the maritime order between South and North Korea should be managed in a stable way. It is necessary to raise awareness of marine spatial planning and utilization in the 5 islands in the West Sea in order to stabilize the maritime order on the Korean Peninsula and establish a peace regime through accurate understanding of the maritime border as originated from the Armistice Agreement.